Hello, welcome back, Concordia University Irvine students. Welcome back, MHA 506, where we are exploring the topic of healthcare law. Welcome back. I'm Dr. Gooden, also known as Dr. D. And let's talk about week two. So, week two, we start to get into some basic legal issues such as tort law, negligence, and understanding both of those will help you understand your legal liability, and thus you would be reducing your risk or reducing your legal liability as it relates to that. So, when we talk about tort, a tort is an action or admission that gives rise to injury or harm of another person. And this is within the civil context, so there would be no criminal liability. However, the court does impose liability on tort injury, and it's usually described as some type of an invasion of a legal right, whereas the harm describes a loss or a detriment to the individual that suffers the tort. Um, and so when we look to tort law, and by the way, I'm quoting directly here from Cornell Law School. So when we talk about torts, we're really talking about providing relief to the injured party that was harmed by the other. And really, the purpose of any court case or court holding within the context of a tort is to bring the injured party whole or bring them back to where they were before the harm or before the tort occurred. So, torts impose liabilities on parties responsible for the harm or the debtor or the other person that commits a harmful act. And so ultimately, what it does, it shifts the burden of loss from the injured party to the party at fault, who is better suited to bear the burden of the loss. And so, yeah, in a lot of ways, torts fall into three categories. There's intentional torts, so battery, when you make physical contact with the person without their consent or something that's closely attached to their body without their consent, would be the intentional tort of battery. And then you have negligent um torts where, and we'll talk more about negligence in a minute, but negligence is where you owe the person some type of duty of care that you either omitted or that you violated. And then there's strict liability, and strict liability torts don't necessarily look for what we call a mens rea, which is a motivation or premeditation, if you will. So, a strict liability, once you break the law or once you make a defective medical product, for example, there is no wiggle room. A strict liability imposes liability on the party that caused the injury or caused the harm without the benefit to determine, let's say, in negligence, does the person have a duty of care, if you will? And speaking of negligence, which is actually one of our topics there, there's usually four elements to negligence, and that could be five depending on what jurisdiction you're looking at. But ultimately, when we talk about negligence, there's four or five major areas that need to be covered. By the way, I'm still kind of quoting, if you will, from Cornell Law School. Something else you want to understand about negligence: negligence is the minimum liability that is available in our system, meaning that in the absence of everything, in the absence of laws, in the absence of statutes, in the absence of any type of uh, law, rule, or regulation that governs a person's conduct, uh, negligence is the minimum criteria, meaning that when there's nothing else available, or if there was nothing else available, the law can still be pursued under the guise of negligence here. So when we look at negligence, in order to establish what we call in law a prima facie case, which just means basic case, there needs to be some type of legal duty that the defendant owed the plaintiff. So if it's you and the plaintiff, or the plaintiff and the defendant are driving down the street in a regular city environment where you have stop lights and stop signs, and the uh, plaintiff runs the red light and hits the defendant in the intersection. Obviously, there's traffic laws and other types of infractions or statutes that cover that. But the point I'm making here is that the person that ran the red light had a duty of care to the other person to stop at the red light, or to stop at the stop sign, or to follow basic laws. And so that's the first part. Does the defendant owe the plaintiff a duty of care, or was that duty of care omitted by the uh, defendant? Number two, did the defendant breach the duty? Did they run the red light? Did they fail to stop at the stop sign, if you will? And that's two. And if so, three, did the plaintiff suffer injury? Was their car damaged in the accident? Did they have some type of physical injury that related to that? And then four, is there proof that the defendant's breach actually caused the injury itself? And that could be established through proximate cause. And so the point there on number four is, was the defendant running the red light or failure to stop in the at the stop sign the direct cause, right? The proximate cause of the uh, plaintiff's injury? And if so, then you have determined the basic case, or the prima facie case for negligence. And there's some wiggle room there, right? So let's say if the defendant did run the red light, but they ran it in a way to where the plaintiff had one last opportunity to stop, even though they were in the right going through the intersection at the green light, but something established to say, well, the plaintiff still, even though the defendant ran the red light, the plaintiff still had the opportunity to stop, then you wouldn't have proximate cause. Or if something else intervened between the time that the defendant ran the red light and caused, and harm or injury was caused by the plaintiff. If there was a superseding event there, uh, maybe a fire hydrant put water on the street, or maybe there was some type of a manufacturer defect, if you will. Uh, anything that directly interrupts the cycle between the defendant's action and the harm that was caused by the plaintiff. Anything intervenes there, there's no proximate cause, and you do not have a prima facie case for negligence. However, that doesn't mean that you don't have other legal cases, but we're just talking specifically about negligence in this case. Okay, I think that's enough. So basically, understanding that will help help managers and help people that are responsible for compliance or risk reduction in hospitals limit their risk, reduce their risk, and limit their legal liability. As far as week two goes itself, you've got your Christian message there. Why would God give such law to his people when we reflect on the question of the biblical foundations? Chapter three and chapter five of the textbook, The Legal Aspects of Healthcare Administration. There is a video this week, The Biblical Foundations of Law 2, and it does deal directly with torts. And again, some people are confused between torts and criminal liability. Torts Courts use torts to hold people responsibility for harm and for lost property that's outside the context of criminality or criminal liability. So that's the difference, right? The harm or the injury that I caused on you would could be from negligence or some other type of even more stringent legal duty that I have for you with the tort, but it doesn't rise to criminal liability. That's the difference there. You've got your self paced lesson, which deals with ethics of the American Medical Association and what happens when bad outcomes are unavoidable, strategies for communicating um, consequences in pediatric care. You've got your discussion forum. Thank you very much for the just the thoughtfulness that you have in your discussion forums and the support from the outside sources. It means the world. Thank you very much for that. And your individual assignment this week is the case brief, Hastings versus Baton Rouge General Hospital. Now, remember on those case briefs, right? Follow your IRAC format, follow the format that's been laid out in front of you. You have plenty of resources for IRAC. You can also do your own research for IRAC and the method that best works for you. Just please make sure that you're getting your sources or your aids, if you will, from a reliable and ideally scholarly source. Keep in mind that these cases have already been briefed, that there is a wealth of information on these topics scattered across the internet. And if we weren't in an academic course, it would be perfectly okay with you to borrow from the wealth of knowledge that's out there. But since we are in an academic course, there are strict protocols that you have to follow as it results to plagiarism by the university, and we realize that often it's intentional. And so I'm going to invite you to go back and watch the must watch video on plagiarism. It's posted to the announcement section. And then please, please, please make sure that you are citing anything that you're bringing in from the outside, which should be everything. Please quote it either according to APA version 7 or according to Blue Book. And if you don't know the Blue Book citations, it is perfectly okay. But please at least use a minimum of APA. And I think I mentioned this earlier, but it bears saying again. The Blue Book citation for your cases are actually already right there in your description. So when you click on that, uh, or just copy and paste that, that is the actual Blue Book citation. So there you go. And then finally, here in week two, you've got Project One Milestone. Remember, you have your resources there. You've got a laundry list of contracts that you can choose from for your contract and context analysis. If you have access to a contract that you want to analyze, that's perfectly fine too. If there's some questions about that, please send me an email and I'll be glad to look it over and give you confirmation that it is okay to do it. But again, the sooner you get better, the sooner you get started, the better. And so in week two, you're just going to submit maybe a one page, 2 to 3 sentence summary supported by journal articles on what topic or what contract that you are analyzing. And that's it for week two. So I will be having office hours on Wednesday at 6 p.m. Pacific. You don't have to make an appointment. If you don't want to, just feel free to log on there and we'll do a free flow session. If that time doesn't work for you and you need to reach out to me one on one, please send me an email and I'll be more than happy to set up a one on one session for you. Thank you very much for all your hard work, friends. Thank you very much for the thoughtfulness and the rigor that you put in each posting and in each assignment. It is greatly appreciated. And I'll see you in the chat rooms.